Imagine you were searching for your own name. Not a password, not a document, not a legal filing, your actual name. The name you were given at birth by the person who carried you. Imagine that the answer exists, that it is written down in a government office somewhere, that it has your face and your mother's face and your father's name, all on the same page, and that the law says you are not allowed to see it, not because the information is dangerous, not because it was lost, but because sometime in the middle of the 20th century, a coalition of social workers, adoption agencies, and state legislators decided that you should not know where you came from. And then they built a legal wall around that decision that has held for nearly a century. This is the story of how that wall got built. This is not a conspiracy theory. This is documented legislative history, with named statutes, named organizations, named lobbyists, and named financial interests. Most people, if they think about sealed adoption records at all, believe the sealing was done to protect the birth mother. An act of compassion, a way of letting a woman who had surrendered a child move on with her life. That story is told so often and so confidently that it has become something like received wisdom. But it is almost entirely false. The proof is hiding in plain sight in the years before 1935, when every state in America operated under a completely different system, one in which adoptees had the same access to their own records that any citizen had to any public document. Before the sealing, adoption records in the United States were public records. Birth certificates, court records, the original filing listing the birth parent's name. All of it was accessible. An adopted person who wanted to find their birth family could walk into the county courthouse and ask to see the record. In most states, they could get a copy. The state of Minnesota had no restriction whatsoever on adoptee access to original birth certificates before 1917. Illinois had no restriction. New York had no restriction. The openness was not accidental. It reflected the legal understanding of the era, which treated adoption as a civil proceeding and birth records as civil documents, the property of the person whose birth they recorded. Formal legal adoption, as we understand it, was itself a relatively recent invention in 1900. Massachusetts had passed the first modern adoption statute in 1851. The sealing of records was not part of the original design. It was added later. The dominant model of adoption in the early 20th century was not the agency model. It was the independent placement, a private arrangement brokered by a doctor, a lawyer, a minister, sometimes just a neighbor. The infant welfare movement of the progressive era began pushing back against this system in the 1910s and 1920s, arguing that private placements were unregulated and that babies were being bought and sold. The solution the infant welfare movement proposed was not simply to regulate independent placements. It was to professionalize adoption entirely, to route every adoption through licensed social work agencies staffed by trained caseworkers. Licensed adoption agencies were not free. They charged fees for their services. Fees for the home study, fees for the placement, fees for the legal processing. By the 1930s, a private adoption agency in a major American city might charge a family hundreds of dollars to complete an adoption, weeks or months of average wages. The agencies also received government funding in many states because they were classified as child welfare organizations. This meant the professional social work establishment had a direct financial interest in controlling the adoption process. The argument for sealing, when it was first formally advanced, was not primarily about protecting birth mothers. It was about protecting the adoptive family. Social workers in the 1930s argued that open records created instability in the adoptive family, that an adoptive child who could find their birth parents might feel less connected to the adoptive parents. The sealed record, in this framing, was a product guarantee. It was the agency saying, "We have built you a complete family, and we are going to use the law to make that family permanent." Minnesota sealed its adoption records in 1917, the earliest such action in the country. The Minnesota Children's Home Society had been advocating for greater state regulation of adoption since the early 1900s. The sealing was not presented as a dramatic policy change. It was presented as a technical administrative measure tucked into a broader child welfare statute. Almost nobody outside the social work profession noticed it. The logic it established, that adoption records were not public documents but confidential case files, the property of the state and the agency rather than the individual whose birth they recorded, was the logic every subsequent state would eventually adopt. New York sealed its records in 1935. This is the pivot year that historians of adoption policy return to again and again because New York's action set the template that most other states would follow. The New York Charities Aid Association had been working for years to bring New York adoption practice into alignment with what they called the professional standard. The sealed record was central to their vision. Their argument to the legislature was sophisticated. They talked about protecting children from the stigma of illegitimacy, about protecting birth mothers from harassment, about protecting adoptive families from legal uncertainty. Every argument was framed in terms of protection, but every argument also had the effect of routing more control through licensed agencies and their professional staff. By 1948, nearly every state in the country had sealed adoption records in some form. The Child Welfare League of America had made sealed records a standard of professional practice. To be a legitimate, accredited adoption agency was, by definition, to operate under sealed records. Any social worker who argued that adoptees had a right to their own information was, by the logic of the accreditation system, operating below professional standards. This is the closed loop. The agencies charged fees for adoptions. The fees depended on their legitimacy. Their legitimacy was certified by the Child Welfare League. The Child Welfare League required sealed records. The sealed records prevented adoptees from accessing information independently, which meant that any adoptee who wanted to search would eventually need the agency's cooperation, which the agency could provide or withhold at its discretion. The sealed record was not just an administrative policy. It was a choke point. It was the mechanism by which an entire professional establishment maintained control over information that belonged, by any reasonable moral standard, to the people it described. Estimates suggest that between 5 and 10 million Americans were adopted through closed record systems in the 20th century. Of those, studies found that the vast majority, somewhere between 70 and 80%, wanted access to their original birth records, not to disrupt anyone's life, not to make legal claims, simply to know their medical history, to know the circumstances of their birth, to know who they looked like. Jean Paton is the name most people have never heard, but she is the person who first built the modern adoptee rights movement on the foundation of that hunger to know. Peyton was herself an adoptee, born in 1908, who spent years searching for her birth mother before finally finding her in the 1940s. She published a book in 1954 called The Adopted Break Silence, which collected third-person testimonies from adoptees about their experience of searching and of the sealed record system. It was the first systematic documentation of what adoption felt like from the inside, and it was devastating. The adoptees Patton interviewed described the sealed record not as a bureaucratic inconvenience, but as an existential wound. Peyton founded an organization she called Orphan Voyage in 1953, the first mutual consent registry in the United States, a place where adoptees and birth parents could register their willingness to be found. The social work establishment was hostile. The Child Welfare League ignored her. State welfare administrators dismissed her work as sentimental and unprofessional. Peyton spent decades advocating for a change that seemed to the people in power both unnecessary and threatening. She died in 2002, still fighting. She never saw a federal adoptee rights law passed. Florence Fisher picked up a thread of the same argument and pulled it into the public consciousness in the 1970s. Fisher, also an adoptee, spent 15 years searching for her birth parents before finding them in 1965. She founded the Adoptees Liberty Movement Association in 1971, known as ALMA, and she testified before state legislatures, appeared on television programs, and published a memoir called The Search in 1973. ALMA established search networks across the country, informal systems of volunteers who helped adoptees navigate the gaps in the sealed record system, cross-referencing public records, hospital records, church records. These networks were, in a very real sense, working around an information embargo. And the establishment's response was to tighten the embargo. In state after state, adoptee rights advocates introduced bills that would open original birth certificates to adult adoptees. In state after state, they were defeated. The opposition was organized, well-funded, and drew on a coalition that included adoption agencies, the National Council for Adoption, which was founded in 1980 specifically to oppose open records legislation. The National Council for Adoption represented licensed, most religiously affiliated private adoption agencies. Its members charged placement fees. Its members depended on a legal environment in which the state sanctioned their role as the intermediary. Open records, records that adoptees could access directly without going through an agency, threatened that intermediary role. The NCFA understood this. Their legislative strategy was calibrated to it. The NCFA's founding president, William Pierce, argued publicly and repeatedly that open records would cause birth mothers to choose abortion over adoption because they would fear future contact from the child they had placed. This argument was testable because by the late 1970s, England and Wales had opened their records in 1975, and Scotland had never sealed them. If open records caused a drop in adoption placements, the British data would show it. It did not. Adoption rates in England and Wales did not decline following the opening of records. Birth mothers did not avoid adoption agencies out of fear of future contact. The argument Pierce was making was empirically falsified by the available evidence. He continued making it. Oregon passed Measure 58 in 1998, a ballot initiative that gave adult adoptees unrestricted access to their original birth certificates. It passed with 57% of the vote. The NCFA and its allies challenged it in court immediately. They lost at every level. When Oregon's records were finally opened in 2000, the catastrophe the opponents had predicted did not materialize. Approximately 20,000 adoptees obtained their original birth certificates in the first few years the law was in effect, and the majority of those searches led to contact, and the majority of that contact was described by both parties as positive. Alabama had actually opened its records briefly in 1998 and then resealed them under legislative pressure. A state opens records, nothing bad happens, and then closes them again anyway, not because of evidence, because of lobbying. Tennessee opened its records in 1996 following a court ruling. The law that finally went into effect included a contact veto system, a mechanism by which birth parents could indicate they did not want contact. The contact veto was used by a tiny fraction of birth parents who registered. The vast majority did not object to contact, consistent with every survey of birth parents that researchers had ever conducted. Studies by Annette Baran and Ruben Panner, by Katerina Wegar, by Gail Slapp and colleagues, all documented the same basic finding. Most adoptees wanted information about their origins. Most birth parents were open to contact. The sealed record was not serving any identified population's expressed wishes. It was serving an institutional interest in continued control over information. The American adoption industry generates revenues estimated at somewhere between $13 and $14 billion annually in the United States. The portion of that revenue that flows through licensed private agencies depends on a legal environment in which those agencies are the necessary intermediaries. To the extent that open records reduce the need for agency intermediation, to the extent that an adoptee who can access their original birth certificate does not need to hire anyone to conduct a search. The open records movement represents a structural threat to a significant portion of that revenue stream. The DNA testing industry generated approximately $2 billion in consumer revenue in 2023. Companies like Ancestry DNA and 23andMe have, in the span of roughly a decade, done something that 50 years of legislative advocacy could not accomplish. They have given adoptees a practical path to identifying their birth families that does not require any cooperation from any state agency or any adoption agency. An adoptee who submits a saliva sample and who has a sufficient number of relatives who have also tested can, in most cases, identify their birth family through genetic genealogy. The closed record system, in biological terms, has a back door. The adoption agency establishment's response to the DNA testing era has been revealing. The NCFA and its successor organizations have not reversed their position on sealed records. Instead, they have pivoted to lobbying for regulation of genetic genealogy, arguing that DNA databases should be subject to privacy restrictions that would limit their usefulness for exactly the kind of adoptee searches that are now occurring by the millions. The suppression mechanism is adapting. The goal remains the same: Bastard Nation. The adoptee rights organization, founded in 1996, named themselves with a deliberate provocation. The word bastard, the legal term for a child born outside of marriage, is the word the sealed record system was originally designed to erase. An adoptee who received an amended birth certificate, listing their adoptive parents as if they had been the birth parents, was receiving a legal fiction, a state-certified falsification of a vital record. Every adoptee in the closed record era received a new birth certificate upon finalization of their adoption. This certificate listed the adoptive parents' names in the spaces for mother and father, on a document that began with the word certificate and was supposed to certify facts. In most states, to obtain a copy of your own original birth certificate as an adult adoptee, you would need a court order demonstrating good cause. A medical emergency might qualify. Curiosity did not. The comparison to other suppression patterns in American regulatory history is uncomfortable but necessary. In the pharmaceutical industry, manufacturers have suppressed research demonstrating the availability of cheap generic alternatives to profitable branded drugs. In the telecommunications industry, the suppression of municipal broadband has been achieved through state-level legislation drafted by lobbyists, employed by incumbent providers. In each case, the mechanism is the same. An institution with a financial stake in an information or service aids bottleneck uses its political influence to make that bottleneck legally permanent. The adoption records case is the same pattern applied to vital records, the most personal category of government document that exists. The bottleneck is the sealed record. The institution with the financial stake is the licensed adoption agency establishment, the beneficiaries of the sealed record. The adoptees whose medical histories are incomplete, whose genetic identities are legally obscured, who have spent thousands of dollars and decades of their lives searching, never had a seat at the table when these decisions were made. As of 2024, fewer than half of the states in the United States provide adult adoptees with unrestricted access to their original birth certificates. States like New York, which sealed records in 1935, only opened them fully in 2020, 85 years later, following decades of advocacy. States like Florida still require a court order in most circumstances. The patchwork of state laws means that whether you can access your own birth record depends entirely on where you were born, a fact determined not by any principle of justice, but by the historical accident of which states had strong adoption agency lobbies in the 1930s and 1940s. The adoptees who searched before DNA testing, who worked through ALMA and Orphan Voyage, and the informal networks of volunteers who spent years and sometimes tens of thousands of dollars on private investigators and court petitions. Those people paid for a service that should have been free. The information was always there. It was written down. It was in a file. What they were paying for was access to a record of their own birth that the government was withholding from them. A record that prior to 1935, they would simply have been allowed to see. That is the shape of the injustice. Not a secret plot, not a conspiracy in the movie sense. A business interest, a professional establishment, a regulatory framework, and a legislative strategy. All of it documented, all of it named, all of it still operating in the present day. The wall is still standing in most of the country. It was built in living memory, and most of the people on the other side of it are still searching. So here is the question this history leaves open. In a world where DNA databases have effectively made the sealed record obsolete for anyone with enough relatives who have tested, does the legal battle to open those records still matter? If you can find your birth family with a cheek swab and a $100 kit, does it matter whether the paper record is technically accessible? The adoptees who are still fighting for rope and preachers nexus. Because the legal right to your original birth certificate is not just practical. It is the state's acknowledgement that you are who you are, that your origins are real, that the facts of your birth belong to you. A DNA database gives you genetic information. An open record gives you legal recognition. And the difference between those two things, between knowing and being officially permitted to know, is the difference that the sealed record system was designed to exploit. If you have a story about this, if you are an adoptee who searched, or a birth parent who was found, or someone who works in the system and sees it from the inside hot, the comments are where this conversation belongs, because this history is not finished. The records are still sealed in more states than they are open. The lobbying is still happening, and the people most affected by it are still, in 2024, fighting for access to the most basic document of their own existence.